Robin Castleman, and I'm joined today with Emily Roark and Tyler Brown, and they're with the Bryant Law Center, and they're going to be answering some of the questions you all have sent in. Are you guys ready?
Yeah, let's go.
All right, well, let's start with our first one. This one says, my son refused a breathalyzer Saturday night when he was pulled over and later passed the blood test. Can he be in trouble for refusing the breathalyzer?
I'll take that one. Unfortunately, yes, he can. So the law on that says that you have to take any and all breathalyzers that they try to give you, or blood or alcohol tests. So if they give you in any order, so if you try a breath test and you can't take it, I had someone talk to me recently, they tried to blow into the breathalyzer 5 or 6 times and they couldn't. And so then they were asked for blood. And yes, if no matter how many of those they ask for, blood, breath, or urine, you have to give one or all 3, or it's considered a refusal.
Gotcha. That's good to know. I think that's a multiple question that people have.
It's very confusing too, because people think, well, I gave you one, but sometimes they'll get that breath and you'll be under, and so then the officer may think, well, maybe they have some drugs or something in their system, so they'll go ahead and take you down for urine or for a blood test. So yes, you have to give all of them.
Gotcha. Good to know. All right, this one says, I was at a private party and got busted for underage drinking. I'm 21 and I was sitting in my car in the driveway talking to a friend. They arrested me for a DUI. Will those charges stick because it was on private property?
Okay. That's a good question, Robin. I'll take that one. Yes. You want to look at the circumstances in this case, but as far as operating a motor vehicle, it's not strictly limited in Kentucky to a roadway or a highway. They could be on your private property, parking lot. What it's really going to focus on is operation and control of that vehicle. So in the question, there may be some defenses there if the vehicle's turned off, if you're just sitting in it to get out of the weather and you're not actually operating or controlling the vehicle. You may have some defenses there as far as operation, but as far as the roadway, it's not really strictly limited to roads or highways or interstates. It can be on private property, it can be on farm property. If you're operating that vehicle under the influence and you have operational control over it.
So whipping it into the driveway ain't gonna save you.
No. No, and kind of to play on that, we've had DUIs on tractors, we've had DUIs on golf carts, so to extend that, just being on things other than a car can get you a DUI too. So just remember that if you're on a roadway of any kind, in any kind of operation of a vehicle of any sort, you could get a DUI.
Just be mindful of that. Okay. Quickly, my daughter got a DUI 15 years ago while she was in college. Can she get that expunged from her record?
Okay, another good question. In Kentucky, yes, states vary as far as the look-back period. In Kentucky, it's a 10-year look-back period, so I would say if this is an offense that occurred 15 years ago, she's going to be able to qualify for that. And typically you have to add the probation period, which sometimes can be up to 2 years, so she's even beyond that. So I'd say it's very likely you talk to an attorney, you could get that expunged.
Well, that's good news. Good news. Okay, our next caller says, my husband takes strong prescribed pain medication for his back. He was involved in a car wreck and they have charged him with a DUI. Can we get those charges dropped since it was prescribed medication?
That's a good question, and Tyler, jump in here if I don't cover everything. There's a lot to answer in that. So you can still be under the influence even if you have a prescription medication. So the question is going to be, first they're probably going to ask for blood in that case, and the question is going to be if you are under the influence. So the first thing is you have to have a prescription, and there's a whole list of things that you can't drive under without a prescription. And then the second question is going to be if you are over the therapeutic limit. And so those are the 2 things that's really going to matter. Usually there's going to be blood, there may be urine too. I think the blood's much more important than the urine, but those are the 2 things you really need to watch out for. So if you have a very strong medication that you take for your back, just make sure that you're not taking so much of it that you can't operate without feeling under the influence of that drug. And because you use it a lot, you may not know that you're under the influence. So maybe ask someone else what they think before you drive and those sorts of things.
Great advice. Great advice. Okay, this next question says, my son was detained by an officer but not arrested, and the officer asked him a lot of questions. He was scared and answered them. Then they arrested him. Did he have to answer any of the questions?
Okay. That's a good question. I will say, as far as an officer's going to have the ability to ask you, your name and have you produce ID, and I think you should comply with that. But as far as questioning about any kind of criminal activity or things like that, you have a right to not answer any of those questions. You have a Fifth Amendment right to not do that, or to have attorney present. So kind of going to that question, as far as if you say that you're detained, what you've got to look at as well, there may be issues there as far as using that statement in court. If a reasonable person didn't feel free, that they were able to leave, to disengage from that conversation and walk away, then the law looks at it, in the sense that you are under arrest at that point. If you're not, if a reasonable person wouldn't feel that they're free to leave. So an arrest isn't always necessarily equal being placed in handcuffs or placed in a cell or taken to the police department. So you kind of have, an attorney has to look at that situation to see whether or not, there may be a Miranda violation, because if you are detained, if you are under arrest and you're questioned, an officer does have to inform you of your rights to have an attorney present or to not answer questions that can incriminate you. So it's very situational. It's not always clear cut whether or not you're under arrest. It isn't always, like I said, it doesn't always equal, that you're being placed in handcuffs. But I'd say as a baseline, if an officer asks you, produce ID, asks you what your name is, that you should comply with that. But beyond that, you've got constitutional rights that, guarantee that you don't have to answer questions that can incriminate you.
Thank you. Thank you for clearing up some questions that our
Absolutely.
viewers have, and we appreciate you all being here.
Thank you. We appreciate you.
If you would like to revisit this segment of Legal Line, log on to WPSDLocal6.com and click Legal Line.